Hi, this is Chuck Stull with an introduction to antitrust in the United States. The U.S. has had a strong disposition towards market solutions, and that means it's important that markets function well. And antitrust makes markets work by preventing the problems of monopoly. But we will consider the antitrust laws in some detail, and we'll be looking at some important aspects and cases. Right now, I'd like to look at the major concerns, the major laws, and the types of enforcement. Supreme Court Justice Marshall um, argued that antitrust is essential for free enterprise and economic freedom. He said antitrust laws are the Magna Carta of free enterprise. They are as important to the preservation of economic freedom in our free enterprise system as the Bill of Rights is to the protection of our fundamental personal freedoms. So let me turn to the major concerns of antitrust. Um, First is price fixing. Second, monopolization. Third is mergers. And fourth is anti-competitive business practices. And we'll be exploring each of these in some detail. Now, these broad concerns go back a couple of centuries. Adam Smith warned against business conspiracies to raise prices in 1776, saying people of the same trade seldom meet together, even for merriment and diversion, but the conversation ends in a conspiracy against the public or in some contrivance to raise prices. Henry Clay, a well-known senator from Kentucky, praised the benefits of competition well before the Civil War, saying, of all human powers operating on the affairs of mankind, none is greater than that of competition. So let me turn to our major antitrust laws. The first is the Sherman Act of 1890, which we've discussed earlier. Section 1 prohibited price fixing and restraint of trade. The example that we looked at very early in this class was the dairy industry bid rigging, which was a violation of Section 1 of the Sherman Act. And then Section 2 prohibited monopolization. And the example here we saw was the Standard Oil case, where Standard Oil ended up being broken up into many competing companies. The second major antitrust law in the United States was the Clayton Act, and this was passed in 1914. So it strengthened the Sherman Act. It reacted to court interpretations. For example, it explicitly removed labor unions from antitrust action, which we talked about earlier, and it made some violations more explicit, and it added some important provisions. So, Section 2 of the Clayton Act restricted price discrimination, except under certain circumstances. Section 3 restricted some unfair business practices like tying, which is requiring a purchase of another good along with a good, or exclusive dealing, which would prevent retailers from buying from another firm. And Section 7 restricted mergers. Now, not all mergers, as we'll see, most mergers are legal, but mergers that substantially lessen competition were prohibited by the Clayton Act. Now, mergers to monopoly had already been prohibited by the Sherman Act, but this is a different standard, and tools like the four-firm concentration ratio, which we talked about early in the class, and later the Herfindahl Index, were developed to measure changes in market concentration in terms of Section 7 of the Clayton Act. Now, passed in the same year was the Federal Trade Commission Act. So the Federal Trade Commission, or FTC, is a government agency with multiple responsibilities. One of those important responsibilities from our perspective is to enforce the Sherman and Clayton Acts, or to be an antitrust enforcer. But they're also very active in consumer protection, working against fraud and deception, promoting truth in advertising, the do not call legislation, and some of the anti-spam legislation is enforced by the FTC. Section 5 of the Federal Trade Commission Act addresses unfair methods of competition and was originally seen as giving the FTC authority to enforce antitrust in the Sherman and Clayton Acts. In recent years, we've seen the FTC bring violations of Section 5 as a charge on its own. So this would be beyond the Sherman and Clayton Act, giving additional protection for competition and for consumers. So the Federal Trade Commission does have responsibilities beyond antitrust, consumer protection, advertising, privacy, identity theft, and so forth, but we're going to be focusing for the most part on antitrust in this class and certainly this week. Antitrust has an interesting enforcement history. The degree of enforcement has varied substantially over times. Sometimes the enforcement has been very strict, blocking a merger of two small grocery chains in Los Angeles, for instance. And other times it has been very loose, allowing mergers of oil supermajors like Exxon and Mobil. Let me talk about a few factors that have contributed to this variation in the strictness of antitrust enforcement. First, we must talk about court decisions. The US is a common law country, and that means that court decisions create precedents. And a US Supreme Court decision is binding on all lower courts in the United States, both federal and state courts. So if we have a strict interpretation by the US Supreme Court, we're going to see stricter antitrust enforcement. On the other hand, if the US Supreme Court overturns an antitrust rule, we will then see looser enforcement. A second factor that has caused changes in the strictness of antitrust enforcement is the presidential administrations. Presidents appoint antitrust authorities, and some of them have more enforcement effort, and other ones have less enforcement efforts. For example, President George W. Bush said, "My own personal view is the application of antitrust laws needs to be applied where there are clear areas or clear cases of price fixing." So George W. Bush was missing monopolization, mergers, unfair business practices, and the antitrust enforcement under his administration was seen as particularly weak. President Obama was seen as stronger, and he specifically appointed officials who would strengthen antitrust enforcement. President Trump has been stronger on antitrust than expected, and partly as we came in with a couple of different elements, and that is, as a pro-business candidate, people expected that he would be weak on antitrust, but as a populist, people expected that he might be strong on antitrust. And he has seemed to have, after a slow start, been relatively strong on antitrust enforcement. A third factor that has been much more important in this area of law than in other areas is academic research. Academic research has been very influential in swaying enforcement, either weakening it or strengthening it. And a lot of economists have had a large role to play here. At times, courts and antitrust enforcers have considered economic models published in academic journals and directly applied them to the law. There are certain areas of the law that, because economists say, oh, it's not a rational behavior, that are no longer enforced, even though the laws still stand. Now, if we look at enforcement, there are a few different ways that antitrust laws are enforced. So at the federal level, the Department of Justice, Antitrust Division, and the Federal Trade Commission have overlapping jurisdiction. Either of these government agencies can bring civil cases. The Department of Justice can also bring criminal cases. There is also the possibility for private enforcement. So if someone is hurt by restraint of trade, they can then sue for damages. So for perhaps a business pays an extra $1 million due to collusion among its suppliers, it could sue those suppliers. And it would be eligible for what are known as treble damages. Treble simply meaning triple or 3 times. So if they had been hurt by $1 million, they could sue for $3 million. The In some cases, we see states bringing antitrust cases on behalf of their citizens, and states also can enforce state antitrust law um, for violations that happen within their borders. Now, if we look at the outcomes of antitrust cases, um, many cases come to a conclusion without getting to a guilty or innocent verdict. The most common outcome is a settlement. About 90% of private cases are settled out of court, frequently for a dollar payment from the violators to the plaintiffs. On the public side, uh, a frequent outcome is a negotiated settlement called a consent decree. So this is a binding court agreement, and it often would be to change pricing policy or to stop a behavior that was seen as anti-competitive. Um, we can also have direct orders from a court to stop a behavior, to stop acting in a particular way. We can have companies found guilty and fined. The fine is different than damages, right? That is money that goes directly to the government. Damages go to private properties. And for criminal cases, we could see and have seen prison sentences for people involved in violation of antitrust laws. From an industrial organization perspective, perhaps the most interesting outcome, although a relatively rare one, is a structural remedy. So we talked about the breakup of Standard Oil, right, which really changed the structure of the oil industry for the next century. So that would be a major structural change. We can have smaller ones where courts block a merger between competitors, or where courts allow a merger but require some divestiture, right, for the company to sell off some of those parts in order to maintain competition. And we will see examples of each of those as we move forward. This has been Chuck Stull talking about antitrust from Kalamazoo College. Thank you for listening.